Welcome to our first live webinar. So indeed, actually, a first webinar that Matthew and I are hosting from our homes, and the first one we've done live. So as we progress, please do type any questions and submit any questions that you may have as we talk through the slides, and we will answer these during relative pauses throughout the webinar, and also we will deal with a number of questions at the end, and we've already had a couple of questions that have come through prior to starting the webinar, so that's fantastic. Thank you very much. And we will at the end answer any questions that we haven't already covered, do feel free to continue to submit questions, because we will be around a little bit beyond the end of the webinar to discuss any issues that you may have. So collective redundancies. Not necessarily a cheerful topic, but one we actually felt important to cover, as we know that it is in fact on many of our clients' minds. And I think given the current pandemic and the significant impact to many businesses that this is having, suddenly that threshold of 20 employees or 20 proposals to make redundancies that will trigger collective consultation suddenly appears quite low compared to perhaps other times. And at the moment, one of the frequent questions we're being asked is actually, can we commence a redundancy process if employees are currently on furlough? Now, not to give the game away and steal Matthew's thunder later on at all, of course, but actually the quick answer to that is yes, we can. And this does include collective redundancies. And of course, many of you perhaps thinking, well, why would you want to wait until the end of the furlough scheme that is due to end at the end of June, when if you wait until it's finished and all your employees back at work and you'll be back to paying full 100% salaries, why would you want to wait to commence a process then? And there also may well be actually for normal redundancies or even collective redundancies, if they extend the scheme, that some of the notice pay may be actually covered by the furlough scheme as well. And we'll discuss all of that later. And another important reason why we wanted to discuss collective consultation today is that if it does apply, then it is crucial that you do carry them out and you do so properly, as a failure to collectively consult, if the obligation applies, can result in a protective award, which you'll see later on can be extremely costly. And indeed, the failure to notify the Secretary of State, which is another requirement, is actually a criminal offence and can result in an unlimited fine. And this is, of course, on top of any potential unfair dismissal claims. So the plan for this morning, I'm going to look at the question of what is collective consultation and when is it triggered. It will be a reminder for you of the key requirements and when it applies. It is a huge topic, and actually it's probably something that we could do on a half-a-day seminar or training session on. And there's lots I could examine in great detail, but actually what we wanted to do this morning was just highlight the key issues that should be considered before commencing a collective redundancy process. Matthew's then going to look at the interplay with furlough. As I've already mentioned, we can start a process now, but there are other considerations we have to have in mind given the existence of the furlough scheme, and Matthew will look at that. I am then going to look at the special circumstances defence. So this is a defence to a failure to collectively consult, and this is a defence that applies where if you can show that it hasn't been reasonably practicable to consult in time. But as you will see, unfortunately, it's not going to be the get out of jail free card that perhaps we hope it would be if you fail to collectively consult. But it is worth us looking at this potential defence and exploring it, because it may be useful. And finally, we're going to consider the practical issues you may encounter with a collective redundancy or normal redundancy process, especially in light of the current lockdown and the social distancing measures. First of all, what is collective consultation? And we've just put up there on the slide the section 188 of TULRCA. So this is where you'll find the requirement to collectively consult. So what does it say? Well, it says where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, the employer shall consult about the dismissals all of the persons who are appropriate representatives for any of the employees who may be affected by the proposed dismissals or may be affected by measures taken in connection with those dismissals. I do see that, actually just pausing here, that a few of you are having some sound issues. Amy, who is working in the background supporting our webinar, is looking into this now, and hopefully she'll will be able to fix that for you. So I will continue on for those who can hear me. And of course, I probably couldn't hear that message at all, but there we go. I just wanted to point out, in case they do later catch up and see the recording, that we are aware and we're trying to fix it. This section 188(1)A basically sets out the minimum consultation periods. So the consultation shall begin in good time, and in any event where the employer is proposing to dismiss 100 or more employees, we need to consult for 45 days and otherwise at least 30 days before the first of the dismissals takes effect. So let's break this down into a little bit more detail. The duty to inform and a duty to consult. So duty to inform. There is a specific statutory list of information that must be provided within section 188. In brief summary, it will include the reasons for the business's proposals, numbers and descriptions of employees who it proposes to dismiss as redundant, requirement to inform in relation to the proposed selection method, i.e. your selection criteria, the proposed method of carrying out the dismissals and the period over which they're likely to take effect, as well as the proposed method of calculating redundancy pay. And there's also some information requirements in relation to any agency workers that you may have. We will look at the information needed to be provided, and in particular how much detail you have to go into a little later on. So that's just a very brief overview at the moment. The information must be provided during the period of consultation, but if you don't have it all available right at the start of the consultation process, that's fine. Consultation can start before all of the information is available. And a classic example there, I guess, would be if you hadn't quite worked out if you were perhaps offering enhanced redundancy payments, what those calculations would be. So that's duty to inform. What about the duty to consult? Again, the statute stipulates these requirements, and we are going to look at this a bit later on. But note that under section 188 of TULRCA, consultation must be with a view to reaching an agreement, and that obviously can be contentious. So duty to inform and consult with appropriate representatives of affected employees. So these could be trade union representatives or employee representatives. Employee representatives, they could be employee reps who've been elected for other purposes in the past, or they may well need to be specifically elected to conduct this section 188 consultation. For many of you, if you do need to carry out collective consultation, there will actually be the need to facilitate the process of electing reps. And where we need to elect reps, again, there are specific statutory rules governing the election of the reps and ensuring the adequacy of representation produced by that election. I'm not going to go into all of that in detail, but what I would say is that, given the current circumstances we are in, with many employees either working from home or indeed on furlough perhaps, there are going to be some practical hurdles to overcome. You also need to allow time for the process of the election before we start the consultation. And I'd also like to remind you that whilst we need to consult with the elected representatives, we also need to carry out individual consultation as well. So don't forget that. There is also the practical issue with ensuring that you have the technology and the infrastructure in place actually to give the employee reps access to the affected employees during consultation. This is an issue at the moment because, of course, if everybody was in the office and working and meetings could could take place in a boardroom, then the access is potentially there. But actually, rather than looking at ensuring facilities are there, we're going to have to ensure that technology is there. And finally, on the first bullet point, well, who are the affected employees? Well, it's not just those who are affected by the proposed dismissals, i.e. not just those that are potentially at risk of redundancy, but it also includes employees who may be affected by any measures taken in connection with the dismissals. And this could potentially, depending on what you're looking to do in your restructure, could be a very wide group of employees, because it includes employees affected by measures in connection with the dismissals. So could include, if you're looking at creating new systems of work, implementing new systems of work, if you're looking at changing working hours or working arrangements, or perhaps even looking at new reporting lines, organizational changes, then actually those employees who are affected by that could potentially need to be consulted with as well. So moving on to the next bullet point, consultation needing to begin in good time. So it needs to begin in good time, and at least for the minimum time period of either 30 or 45 days, depending on whether you're looking at the over 20 or over 100 employees being dismissed. So good time will apply when you're proposing to dismiss as redundant. So when you start the consultation, you need to really be able to show that the proposals are still at a formative stage, and that you haven't just kind of reached the point of no return, because that potentially could be too late. And also note that there is a requirement for meaningful consultation. So it's not just enough for us just to kind of explain our proposals and just listen to any counter proposals. The consultation needs to be meaningful. Matthew will explore in more detail when the consultation should start shortly, particularly in the context of the furlough scheme. And as I'm sure I've already said a couple of times before, the dismissals must not take effect before the end of the 30 or 45 day period, whichever applies. Otherwise, if the dismissals do take effect before this, then there'd be a breach of the collective consultation obligations. And finally, actually, the other thing I wanted to say actually on the time periods is that time period won't run until after we've elected the representatives. So we are going to have to, in our planning, in our timetable, allocate some time to carry out the election process before we can start the consultation, and then the clock starts to run in terms of the 30 or the 45 days. And finally, another key requirement is the obligation to notify the Secretary of State of the proposed redundancies. This is on a prescribed form, which is the HR1 form, and you also need to provide a copy to the elected representatives. And the timing of notification is again 30 or 45 days, depending on the numbers you're proposing to dismiss as redundant. So moving on, I'm just waiting for the slide to appear. When does collective consultation apply? Just breaking this down. So it's when you're proposing to dismiss as redundant 20 or more within 90 days. So proposing to dismiss as redundant, it's important to note that the redundancy definition under TULRCA is broader than the usual standard meaning of redundancy. And it's defined as a dismissal not related to the individual concerned, or for a number of reasons, all of which are not so related. So basically, for example, if we're looking at dismissing and re-engaging to change terms and conditions, i.e. imposing a pay cut, for example, if we're looking at following out that process of dismissing and re-engaging, then indeed that would, those numbers of employees affected would fall under the definition of redundancy under TULRCA. Anybody taking voluntary redundancy would also be included in the numbers. I had a question the other day about employees who have less than 2 years service. They also need to be included in the numbers. There has been one change, I would say recently, but it's probably a few years ago now, but expiry of fixed term contracts are now excluded from the numbers. So within 90 days, well, what we need to do is we have to take it as a 90-day rolling period. So as I said, the dismissals take effect on the date when the employment contract comes to an end. So it's the dismissal date that we need to be looking at. But as it's a rolling period, we need to be looking backwards as well as looking forwards, as it's a 90-day rolling period. And we will discuss staggered dismissals in a little while. So that's all I was going to say on 90-day rolling period at the moment. And finally, it applies when you're proposing to dismiss as redundant 20 or more within employees at one establishment. So this is probably, I could talk for quite a while on the meaning of what is one establishment. There's been a lot of case law on this. So the ECJ considers one establishment to be the unit to which redundant employees are assigned to carry out their duties. However, there is much scope of to argue actually what does this mean? It is actually quite a tricky area. I'm going to kind of fast forward through a raft of case law and just kind of briefly discuss the Woolworths litigation, because that may help some of you who are listening. So in Woolworths, obviously, they went bust and there was a failure to collectively consult when the stores shut and employees were made redundant. And the matter went to the tribunal to determine the protective award. Woolworths argued that each store was a separate establishment, and this potentially had a massive impact on the protective award, given that it wouldn't apply to those employees who worked in a store with less than 20 employees based at that store. The question was actually referred to the ECJ. And the ECJ held that there had to be 20 or more employees in each shop that were proposed to be dismissed as redundant before collective consultation was required in respect of those employees. And it specifically made the point that there is no requirement for the number of dismissals across more than one establishment to be aggregated in order to determine whether the threshold for collective redundancy is met. The ECJ considered an establishment to be a local employment unit, and it said to look at the employees who were assigned to work at the particular shop. So as you can imagine, if Woolworths had a vast number of shops that had less than 20 employees, and this would massively reduce their bill in terms of the protective award. The ECJ guidance kind of said that actually an establishment should be interpreted broadly, and it said an establishment may consist of a distinct entity with a certain degree of permanence and stability, which is assigned to perform one or more tasks and which has a workforce, technical means, and certain organisational structure to allow it to do so. However, there isn't the need to have any of the following. So to be an establishment, you don't necessarily need to have legal, economic, financial, administrative, or technological autonomy. You don't need to have at that establishment a management which can independently carry out the collective redundancies, nor do you necessarily need geographical separation from the other units and facilities of the undertaking. Nevertheless, actually, how an establishment is defined in practice can be tricky, and actually it is very fact specific. So it is something that, would have to look at the facts of an, in a situation where you're looking to perhaps split up sites and argue that they're different establishments, we'd have to kind of drill down to the nuts and bolts of it to draw a conclusion as to whether we felt they could be separate establishments for the purpose of collective consultation. And the final point I would just make is that actually many of your colleagues may well be working from home at the moment. Indeed, for a prolonged period, but just because they may be based at home, that doesn't mean that they are suddenly all different establishments. Just in case we thought that we could run that argument, I don't think that is going to work. And finally, from me for the moment, I'm just going to briefly talk to you about the failure to comply. So, as I've mentioned before, a protective award may be made where there's a breach of the Section 188 requirements. And this is up to 90 days gross pay for each affected employee. And when the award's made for the protected period, and the period basically that the tribunal were making the award, they consider what will be just and equitable in all the circumstances, having regard to the seriousness of the employer's default. But it won't exceed 90 days pay. And the question really for the tribunal when making a protective award is not actually any loss suffered by the employees, but rather the seriousness of the employer's failure. And finally, the failure to notify the Secretary of State. Well, it's a criminal offence, as I've mentioned, and the employer will be liable on summary conviction to an unlimited fine. So this is all pretty significant risks here. And of course, this is on top of any potential risk of an unfair dismissal claims and potential compensation resulting from those as well. And a final point actually to make is that we can't contract out of protective awards in a settlement agreement. A potential claim in relation to protective award can only be settled through conciliation by ACAS. So that is also another important point to note. Right, I think that's enough from me for the moment. So I'm going to pass over to Matthew, who's going to look at how the furlough scheme fits in with all of this.
Okay, thanks, Vanessa. Hello, everyone. So just looking really at how collective consultation is going to work when we are furloughing staff. You know, this radical and massive scheme which has been put in place to help us all manage the effects of the current lockdown. So we all know what the coronavirus job retention scheme is, and many of us are using it. I think the two basic things to remember about it are that the employee and the employer must agree to the furloughing, and secondly, the employee must not undertake any work for the employer during the scheme. So those are the two fundamentals. Everything else, I think, is detail. There's an awful lot of detail there, and also, as you will have no doubt experienced, it's being constantly updated. I think we're on the third or fourth iteration of the guidelines at this stage. So there's some uncertainties around it. One of those uncertainties is obviously, will the scheme be extended? We know it's costing about the same as it costs to fund the NHS at the moment. So long term, it's not going to be viable. I think we will move at the end of June into a new phase of the scheme where we have where we see some kind of phasing through the scheme. So there's probably going to be some changes, and we're going to keep on top of those. Now, one of the things I think is important to remember as context is that one of the purposes behind the scheme was to stop mass redundancies, because at the beginning of this lockdown, you'll remember, before Rishi Sunak made his announcement, it looked like we were going to be in a situation where there were just going to be many millions of redundancies, as businesses just could not afford it. So the scheme was very much about stopping those redundancies. One of the questions we've seen come through in a number of ways recently is just about how the scheme interplays with redundancy and fairness. Now, I think on an individual level, on an individual unfair dismissal level, we are going to see it argued by employees that you should not have dismissed me, you should have stuck me on furlough. And I think the tribunal will be asked to consider the fairness or otherwise of a decision to make redundant when the furlough scheme was there. I think it will depend upon the precise circumstances of each case how that works, but we will just have to see. I think it's also relevant to collective consultation as well, because one of the things we've got to do is to look at the rationale for redundancy. And I think one of the things that employees are going to be saying is, well, you should be using government support, you should be looking at furlough, you shouldn't be doing anything until the furlough scheme is being closed. And I think employers are going to need to think about how they respond to that. My view, I think, is to respond by saying, well, we look at the short-term nature of the furlough scheme and we take that into account in our planning, but long-term we've got to look at the sustainability of our business, and that is why we are consulting about redundancies now. So we've got to be very conscious, I think, of the interplay and of the intentions behind the job retention scheme when looking at both individual and collective consultation and the rationale for doing what we are doing. So some other issues to just consider in this regard. When do we actually start consulting? Now, we knew what happened back in April was that as the 30 and 45-day thresholds for commencing collective consultation approached, employers became more and more jittery and started, through CBI, other groups, to put pressure on the government to stay. Are you going to extend the scheme? Because if you're not going to extend the scheme, we've got to start these collective consultation exercises. And undoubtedly, we're going to be approaching the same sort of considerations over the next few weeks. Indeed, I think it's next Saturday, the 16th of May, when you're going to have to start collectively consulting if there are more than 100 proposed dismissals. So so it's something we have got to take into account, and we've got to be thinking about that deadline. Vanessa referred to some issues around when collective consultation starts, and one of the big issues is, what do we actually mean by proposing to dismiss? And again, as with many of the questions around collective consultation, this has been argued and considered in detail and extensively at European court level. What the court really seems to be saying is it's not enough just to be contemplating redundancy. You have got to go beyond that, and you've got to be in a situation where you can see that there is a very significant prospect of redundancies, but at the same time, it's got to be before you've actually have a settled intention on your redundancy plan. So, classic example is given is, well, we want to close a plant, or we want to close a factory. When the board is considering strategy, when the board has said, well, that factory doesn't really make sense within the context of our business, arguably that's not proposing, that's just contemplating. As and when the board have said, yeah, actually we're going to have to close that factory, that's when we're starting to propose dismissal. So that's when there is a proposal. We've got a settled intent. We can see that redundancies are coming through on that. I think when the factory has been sold and there is no contemplation of being able to redeploy employees, that's too late. You've gone beyond proposing. You're now into a settled intention to make redundancies. How does that translate when we're looking at furloughing and the end of the furlough scheme? Well, I think every employer will be starting to have an idea of the what withdrawal of the furlough will mean. I think whilst the furlough is ongoing, and certainly whilst it's unclear as to what will happen in the future, then it's perfectly possible to say we're not at this stage proposing redundancies, because the furlough scheme is something we can potentially use in one form or another to stop us. So as long as we can see a future for furloughing, and as long as we can say that it's the furloughing that's stopping us having to make redundancies, then I think we are pre-proposal, as it were. I think as soon as we are in a situation when we know that the changes to the furlough scheme or the withdrawal of the furlough scheme put us in a position where we say, well, we're going to have to make some significant changes to our business, to our workforce as a result of this, that's when we're starting to get into a proposal stage. I think when the board are then sitting down and saying, well, this is what we think business will look like after the severe lockdown we're under at the moment has been withdrawn, once furloughing has been withdrawn, and the conclusion to that is we are going to have to make significant cuts, and you are starting to plan where those cuts will be, that's when you're into proposal. Okay, so I think the furlough scheme is just sort of holding everything back to a certain extent, and as soon as we know what that looks like long term, and as soon as we as a business are saying the changes to the furlough scheme are going to mean that we're going to have to make redundancies, and this is when this is really going to start to trigger. So certainly during furlough, we should be working on the assumption that at some point we're going to have to start looking at a redundancy consultation exercise if we want to have a sort of redundancy exercise taking effect as soon as furlough ends. If you want to see how business goes, if you can't conclude what the effects on your business will be, and you're not looking at redundancies at the end of a furlough scheme, then fine. But otherwise, if you want the two to dovetail, as many employers seem to do, then we're going to have to start looking at it during furlough and really following quite carefully what the government is proposing to do. Sorry, I'm just trying to get my screen to click and change slides, but without success. There we are. So one of the other issues that, again, we've started to advise on now is back to this fundamental of furlough, which is you can't have employees working whilst they are furloughed. And we know that we're having to make declarations to HMRC, and so we want to ensure that that there is no prospect of us losing that furlough support because we've had employees working in some way or another. Effectively, the guidance has been updated to say that employee reps can be elected, can perform their duties whilst they are furloughed. Okay, so there's no real issue there, and we're in the same position with employees who are having to be consulted individually or in more of a collective way, or communicated with during furlough about redundancies. So redundancy consultation, both in collective and individual spheres, can continue during that furlough process without forfeiting the furlough payments. So from that perspective, I think furlough will not give us a reason to not consult. Okay, so lots of things to consider there during the consultation process. We also just need to think about what happens with employment contracts, other employee rights during furlough if the decision has been taken to start a redundancy consultation process, and we are consulting during furlough. So what happens if notice is issued but the scheme is extended? And again, there's nothing to stop notice being issued during a period of furlough if that consultation process is ongoing during furlough, and you reach the stage where notice is going to be issued. And this again applies whether we're looking at more than 20 or fewer than 20 redundancies. I think once you've issued notice, if it's lawful notice, so if it's notice under the contract, then if you want to withdraw or extend that notice, you need the employee's consent. So effectively, there's an agreement between you and the employer. So if, let's say, you issue notice now to expire at the end of June when the furlough scheme is due to stop, and in 3 weeks' time, Rishi Sunak decides that the furlough scheme is going to continue during July, then at the moment the employee's employment is just going to end at the end of June. If you want it to continue for longer, then you need to go to the employee and say, right, now that the furlough scheme is extended, we would like to extend your notice to the end of July. If the employee says no, then their employment will end at the end of June. If the employee agrees, then record it in some way in writing, and then it will continue. I think if you're agreeing that in writing, you need to make it clear that it will continue until the end of the anticipated end of the furlough scheme at, say, the end of July. What happens about notice pay during furlough? Does it continue at the furlough rate, or should it be paid at normal rate? Lawyers cop out here, in that this is an area which is very uncertain and clearly is likely to be subject to some degree of litigation at the end of the period. I think many employers are going to be issuing notice during furlough. So again, it ends as the furlough scheme furlough scheme ends, and I think they are going to be trying to pay that at the furlough rate of pay only. Now, it's likely, or the position we were scratching our heads around this morning, we've scratched our heads around it on a number of occasions over the past few weeks. We think the position is going to depend upon the notice provision in the contract. If you have employees who are on statutory minimum notice, so a week per year up to 12 weeks, or no more than 1 week more than statutory minimum notice, then the Employment Rights Act says that if you have an employee who is given notice at a time when they are not receiving their normal salary, so the obvious ones are when they're on sick leave, excuse me, or some form of family-friendly leave, then they are entitled to full pay for that period of notice. So for those employees, statutory minimum notice, no more than 1 week more than statutory minimum, there is a good argument to say that if you're paying them at the moment at 80%, actually for the notice period, they should receive pay at 100%. For employees who are on longer notice periods, so they're on, say, 3 months contractual, or they're in the first 3 weeks of 3 years of their employment and you've got them on a month's notice, and the rules are slightly different. That provision in the Employment Rights Act doesn't apply in the same way. And those employees, you can actually continue to pay them at the rate you are paying them when you give notice. So if you've got someone who's on 3 months notice during furlough, they're on 80% of their salary. If you give them notice, then there is a good argument to say that they are entitled only to that 80% for the period of their notice. So employees may try to challenge that, and we can certainly see that there will be challenges to this through the courts after furlough ends, but that's likely to be where the distinction lies. Obviously, statutory redundancy pay continues to be due for those employees with over 2 years service when they are dismissed. In terms of how we calculate that, I think it's pretty clear that you would take 100% of pay rather than furlough pay as being the calculation point for statutory redundancy pay, or the weekly cap on a week's pay, if that's lower. So I think that's the position for SRP, and it's one of those cases where I don't really think it's worth arguing that furlough pay should be the default. I think it gets more difficult when you're in a situation where you've put employees on short-time working. Many employers have put employees onto part-time working or temporarily reduce their pay during this current lockdown because there's not the same degree of work. I think again there is more of an argument there that actually their statutory redundancy pay should be reflective of the current pay they're on, the lower pay they've agreed. But I think that could be challenged, and I think we will see challenges on that. One of the other issues we've faced, and I know that for many of you this has been a vexed question during furlough, is how holiday works. We seem to be in a position now where the consensus is that holiday accrues, although that's not actually in the employer guidance, it's only in the employee guidance. So we just need to be aware of that. But holiday accrues. And again, holiday, of course, will be accrued holiday will be paid at the end of the employment in the usual way. Many employers are trying to mitigate that liability by requiring employees to take holiday during the period of furlough and/or during that notice period. And again, we think you can do that. The regulation, the furlough guidance seems to allow holiday to be taken. Again, the jury is out as to whether that's at 80% or 100% of salary. Although the safer view clearly is that it's 100%, and there's good legal reason for thinking that it is more likely to be 100% than 80%. The other thing which we are frequently asked now is the extent to which you can require employees to take holiday during furlough. And again, the answer is, or during notice period, during both, again, as a way of reducing your liability. And the answer is you can require employees to take holiday. Many employment contracts would actually give the employee the ability to require employees to do so just by designating a period, and it would be possible to do that. The other way in which it can be done, if your contracts do not contain that notice period, that notice requirement, is you can fall back on the working time regulations. And what the working time regulations say is that the employer can require an employee to take leave, provided they give appropriate notice. What's appropriate notice? Well, it's twice the length of the period of leave itself. So if you have an employee who is owed a week's holiday and you want them to take that in the notice period, you've got to give them at least 2 weeks notification that they're going to have to take that period. Okay, so that may affect the practicability of allowing employees or requiring employees to take some holiday during notice, but certainly it's a possibility, and it's certainly one you can plan, although I think you should be budgeting for the extra 20% to be paid by the employer rather than just paying at the minimum furlough rate. But as I said, the jury is slightly out on that. Okay, so furlough is going to throw up a huge, he's already throwing up a number of issues in terms of how that dovetails with redundancy exercise, both collective and individual. One of the other issues which Vanessa is now going to look at is how it dovetails with this special circumstances defence, which can help people, can help employers who aren't able fully to consult. So Vanessa, I'll pass back to you.
Thank you, Matthew. So the special circumstances defence found in section 1887 of TULRCA. I put it up there for you to see. So if in any case there are special circumstances which render it not reasonably practicable for the employer to comply with the requirements of subsections 1A, 2 or 4, the employer shall take all such steps towards compliance with that requirement as are reasonably practical in those circumstances. So if there are special circumstances that make it not reasonably practicable for us to comply, and we take reasonable steps to comply, then actually there may well be no penalty for failure to collectively consult. So key question, which I think may be on your minds, is, does the special circumstances defence apply to COVID-19? Well, starting point, what's the definition of special circumstances? Answer, there isn't one, which isn't particularly helpful, but there we go. And also, which may not be particularly helpful as well, is the fact there isn't actually much case law about special circumstances either. And we do have a case which, forgive me, I can't remember the name of, but it was back in the 1970s, so potentially before my time, so that's my excuse, which looked at special circumstances, and it said it's something that is exceptional, something that's out of the ordinary. There is another case called the Bakers Union case, which clarifies that insolvency of itself is not a special circumstance. So in reality, what are we looking at? Well, it's really only going to come into play where the event is truly unexpected. And as I said, there isn't a lot of case law on this. So, okay, let's look at COVID-19. Well, I think we could all say it's truly unexpected, and it is actually, a real sudden disaster in many respects. But we still have challenges if we want to run the argument that, COVID-19 was a special circumstance, meaning we couldn't comply with collective consultation obligations. And the first is that we have to show it wasn't reasonably practicable for us to consult in good time or to provide the information. Well, of course, we have the furlough scheme in place at the moment. So it'd be very difficult to run the argument that, we're drastically, rapidly running out of money and there's ongoing, we have an ongoing payroll issue, and therefore that prevented us from carrying out a consultation period for 30 or 45 days. Perhaps if we can show that we couldn't get our staff to sign up to the furlough scheme, which I believe, speaking to many of our clients, is quite rare, but perhaps if we could show that, or if the situation really just is so dire due to other financial pressures, we may have an argument that it wasn't reasonably practical to consult in good time. But even if we can show that there are special circumstances, this doesn't absolve employers from needing to take all steps that are reasonable as per the last bullet point there. And the case law on this point is actually pretty tough. It's pretty harsh, unfortunately. So there's a case, Shannon Engineering, which very briefly, the employers or the business, provides service to a client. There were health and safety concerns, and so the client cancelled the contract with just 3 days' notice. Redundancies resulted. They were the company should have carried out collective consultation and didn't, because they said, well, we only had 3 days. This is a special circumstance. The EAT said that even in those 3 days, the employer should have taken more steps towards compliance. For example, looking at whether there are any alternative roles the employees could carry out, any support that could be given to employees. Some form of consultation still could have taken place, and therefore they found that steps weren't taken towards compliance, because I think the employer there, I just thought, special circumstances, this is special circumstances, we don't need to comply. And there is another case on called Keeping Kids Company. And this is an EAT case, and it reiterated that consultation needs to be begin promptly and to be found to begin in good time. And so here, the company applied for a government grant, and they applied for that grant on the 12th of June. And they stated on this grant form that if it received the grant, it would still need to reduce its headcount by 50%. There was subsequently, so the grant was going through, it looked like it would be received, but there was subsequently a safeguarding issue that arose, and the grant was terminated. And the company subsequently argued that this was a special circumstance, meaning that, they didn't need to comply with collective consultation. So the EAT agreed that actually was a special circumstance potentially, but actually they found the obligation to commence collective consultations started much earlier. It actually started on the 12th of June, because on the 12th of June, when they submitted the form, they were clearly had in their mind that they needed to reduce their headcount by 50% at that stage. So as I say, it's going to be pretty tough to kind of get over the hurdles of A, showing not reasonably practical to consult in good time, and B, to say we haven't taken any steps. The onus is on the employer, which I'm sure you probably would anticipate, but the onus is on the employer to show that special circumstances applies and that it took the steps towards compliance as are reasonably practicable. However, as we see, tribunal kind of is applying a high threshold here. So practically speaking, what does this mean for us? Well, in current circumstances, we may have, a special circumstances defence if perhaps we fall a few days short. So perhaps, the dismissals are taking effect after 25 days rather than the 30 required. And, we've taken every step that we could to comply. I mean, we could argue, where is a detriment to the employees? We did everything that, we could in the timescale that we had. And, these really are difficult circumstances. But on the flip side, the tribunal might say, well, you had the furlough scheme in place, you knew the scheme was coming to an end. It's very difficult, really, actually, to kind of have that crystal ball to see how sympathetic a tribunal would be to the current circumstances. So really, the safest advice is to kind of elect representatives and start as soon as you can, and comply with the collective consultation, and not make those dismissals before the 30 or the 45 days. But practically speaking, if you get into issues, then just do as much as you can. So that is the special circumstances defence. I'm now going to pass back to Matthew, who's just going to consider some more practical issues around both collective consultation and also some of which may overlap to normal redundancy processes.
Okay, thanks, Vanessa. So some practical issues, really picking up on the requirements which Vanessa has set out, plus also the particular environment in which we find ourselves, where we are inevitably going to be consulting in a remote way. What we need to remember overall is that we've got to show that consultation is meaningful, that we haven't just paid lip service to it, that whilst we might not end up with an agreement between us and the employees or their reps, then at least we have considered what they have said, taken it seriously, and responded accordingly. So that's what we're after, meaningful consultation. First stage of that is to look at what needs to be consulted on, what information needs to be provided. In terms of provision of information, there's a standard list in section 188, and it's worth looking through that list and ticking off boxes. And that list includes reasons for the proposal to dismiss, the number of descriptions of employees who it is proposed to dismiss, the total number of employees employed in that role, proposed selection methods, etc. Some of these can appear slightly bureaucratic, and also if you're proposing very drastic changes, actually can appear to be slightly academic. But it's important that they're all ticked off in the letter. In terms of what you need to consult on, well, it's just worth remembering that what you're consulting about is to try to find ways of avoiding dismissals, or to reduce the numbers of employees to be dismissed, or mitigating the consequences of those dismissals. Now, the first is employer reps suggesting other things to do than dismiss. The second is looking at ways of actually reducing the number of employees to dismiss. And the third is more about, and actually much of the consultation takes place on this third point, it's about the level of redundancy payments, what training can be given, what outplacement support can be given, etc. So it's always worth looking at that, but just bear in mind those three fundamentals. How do you start the process if your employees are furloughed, shielding working from home? Well, I think one of the things I'm sure most employers did at the start of all this exercise is to ensure that they could still keep in contact with employees who were working from home. Now, for office-based staff, staff who are used to using computers, IT, etc., it's quite easy. You've got all the details, and so you can keep contact. Can be more difficult if you've got, say, a lot of site-based employees who are not used to being contacted away from the workplace, or who you have not got regular contact with. So one of the first pieces of this exercise may be to ensure that you have up-to-date contact details for all employees, so you can actually get round to them all. Start of the process actually is about making sure you've got employee representatives in place, because the obligation is to inform and consult employee reps rather than the employees themselves. If you've got recognised unions, then it's your recognised unions. If you've already got a good established workplace forum, then it's that workplace forum. If not, then you've got to hold elections. That can be done over email, but again, you've got to factor that into your timescale. And you can't actually start the formal consultation process until you've gone through that election process. And we would say, as a minimum, you need to allow a week to go out to employees and inform them that you are going to need nominations for reps, and then actually to conduct the the election itself. So it's going to be difficult. You need to factor in that time, but you need to try to run an election process. If no employees come forward to be employee representatives, then you provide the information to the employees direct. There's no actual then collective consultation obligation with those employees. It is just a case of informing them of the information and then getting on with the individual consultation exercise. But there needs to be that initial information given to all employees if there are no representatives. In terms of consultation and social distancing, well, clearly meetings are going to be off the agenda. So again, it's going to be looking at remote consultation over Zoom, whatever else. And again, as the employer, you're going to have to think about how that works, so you can have a degree of face-to-face, albeit remote, consultation. Sorry, I've got a problem with the slides. Vanessa, can you just go to the next? Thank you. Some other practical issues just to think about. I think we're going to see confidentiality around the consultation exercise being difficult to maintain, perhaps more difficult than in the workplace. I've just talked about the elections and the need to go out to representatives. One of the big difficulties with that is, as soon as you're saying to employees, can you please elect representatives, then they know that something is in the offing, and I think you need to be going out with wider communications at that point, as well. So information management becomes vital when you're looking at collective consultation. It's going to be very difficult, I think, in the current climate. So again, look at what you're going to do around that. Just remember, you've still got individual consultation to comply with, as well as collective consultation obligations. You can have a perfectly run collective consultation exercise, but if you haven't gone out and individually consulted with employees, then you've still got some unfair dismissal risk. What we normally do on this is to work out a project plan which has collective consultation, meetings and feedback in it, along with individual consultation exercises as well. Individual consultation should start slightly later than the collective consultation process, so that's collective consultation is underway before you do that. Vanessa mentioned staggered dismissals and the fact that we have this 90-day period, and we're looking at whether or not we are making dismissals within that period. I think we're going to find many employers are going to look at staggering their dismissals over a period of time, if for no other reason than cash flow is going to be difficult to manage if you've got some significant numbers of redundancy payments to pay out. So always bear in mind that 90-day period. Are you envisaging making more than, or are you proposing to dismiss as redundant 20 or more employees within that 90-day period? So just always keep that running total going. Again, I've dealt with some of this, so we'll be able to rush through it. Planning carefully, work back from the date you want those redundancies to take effect. Make sure you've got that business case. Important to think about how you are going to deal with redundancies if the furlough scheme is continuing in some way. Make sure you've got your timescales in place. Still go about appropriate selection. Consider redundancy terms. I think many people are only going to be offering the statutory minimum, but it's something you need to be consulting about. You don't need to be agreeing to any request to enhance redundancy pay, but you do need to be agreeing to it. And just preparing that communication timetable. I think getting all that done early is going to be particularly important, given the fact that we are all having to deal remotely. I can just see a couple of questions which I'll deal with quickly. Please, can you confirm when the 90-day period starts from and when it runs to? It's a good question. It does not start until you have got your elected representatives, or you've got your employee representatives, and you have sent them that Section 188 letter with that information that I mentioned, and you have also sent them a copy of the HR1 form, which goes off to the Secretary of State. If you haven't done those two things, your collective consultation period does not start. In another question here, how many reps should we aim for as a percentage of the workforce? It depends very much on the workforce. I think what you have to do is to keep the number of reps manageable, and also ensure that there is a representation across the board. If we have a workforce where we're say taking, if we're taking, say, looking at 100 redundancies out of a workforce of say 400 or 500, then I would be, depending on, I'd probably be looking at 6 or 7 representatives on that basis, but it would slightly depend upon where the redundancies fell. But you need a number which is going to cover the workforce, but at the same time be manageable in terms of just coordinating that collective redundancy exercise. Some other questions. Can the individual cost of redundancy be used as one criteria along with other considerations? Good question. So in terms of the fact that if you've got employees where redundancy payments are going to be very high, can you avoid making those employees redundant and going for employees where the payments are cheaper? Yes, as one of a number of factors. Anything to do, because I think this really follows on with length of service. Length of service can still be used as a criterion in redundancy selection. Cost as well, I think, can be, but it should just be one of a number of factors. But again, clearly, I think employers are going to be able to demonstrate that they are making redundancies for very significant cost reasons at the moment, and it would seem to me that actually trying to keep the total cost down is a fair reason. Can you explain the rolling 90-day period? When does it start and finish? Well, it's always a difficult one, but effectively what you've got to do at any one particular point, you've got to ask yourself whether you are proposing to dismiss as redundant employee 20 or 100 employees within 90 days or less. And you the jury has been always out to the extent to which you have to cast back and look at redundancies you've already made. My view is you don't. You look forward and see what redundancies you are going to be making in the future, and that is where you trigger your obligation to collectively consult. But clearly, where the slight dovetailing of that, well, where the difficulty with that comes in, is if you've got employees who are under notice and you realise you've got to make some more. You've got to make some more redundancies. So it is a rolling period. It's a case of looking at each time you are commencing a redundancy consultation exercise, particularly if you can see you've got phased redundancy consultations coming through time and time, over the next few weeks. You've got to be asking yourself, right, what are we, from this moment here, are we proposing to dismiss as redundant 20 or more employees at one establishment? And if the answer is yes, because of that exercise over there, that exercise over there, and that exercise over there, then we should be starting the collective consultation regime. So it's a difficult one to perhaps sort of nail down precisely, but each time you are starting a redundancy exercise, that's where you should be looking at who's already under notice for redundancy and what other plans there are for that 90 days. Another question. Please, could you clarify how individual consultation fits in with collective consultation? Yeah, I think they are two different exercises, both of which need to be taking place. So the individual consultation exercise is much more significant from an individual unfair dismissal perspective, whereas the collective consultation exercise is a different right, and we've got to remember that collective consultation obligation applies regardless of whether employees have 2 years length of service or not, whereas obviously consultation on an individual basis is more important where you've got employees with more than 2 years service. The way in which I think it should be done, and Vanessa, chip in if you think it should be done differently, is you start with you send out your section 188 letter to your employee reps. You then wait for the first initial feedback from those reps, and that can be important, particularly if you're looking at selection criteria. I would then be looking at saying, right, now having got that initial feedback, here is how we see this affecting the individuals. And these are the individuals which we now think we've got to consult with individually. So we are going to start that consultation. We're going to have those initial consultation meetings with those individuals. Once we've done that, before we move on to the second stage of the individual consultation process, and you know that really there needs to be at least 2 meetings, we are going to have another collective consultation round, so that we can sort of give you any views that have come out of the individual consultation meetings, And you, as the reps, can also have had an opportunity to speak to those who have had those individual consultation meetings and see if there's anything which needs to be fed back collectively. And I would try and keep that pattern going of collective, individual, collective, individual, and using those collective meetings as an opportunity to discuss any themes that are coming out of the individual consultation meetings, which is why I think it just needs to be built in a way which has a schedule laid out, which has both included. There's another question. Can you talk a bit more about the definition of a single establishment? If you have two offices doing the same thing and generally operating as individual cost centres, but with central management, I think you said that these are separate establishments. Vanessa, I think you'd agree that the answer to that one is yes.
Yeah. Yeah.
So yeah, it is a difficult one, and it's always open to challenge. But effectively, if you've got individual shops, individual restaurants, etc., then they will be, on the case law as we see it, in almost all cases, individual establishments. It can get slightly different where you've got some very, very small branch offices, which haven't got any kind of administrative support separately. Then I think there is an argument that they could be seen as part of one slightly bigger establishment. Normally, you would see each site or each plant as an establishment. My perception is where the law has always gone on this is to look at it in a very physical sense, both from a sort of bricks and mortar and also a geographically discrete location. If you have a geographically discrete location, that is likely to be one establishment. There can be situations. So, for example, I've got a client who has a head office in a location, quite a substantial head office, and then it's got a production plant about a mile and a half away. But the distribution centre for that plant is back near the head office, etc. And certainly we've always treated that as one establishment, because there is such a, even though they are a bit separate, even though they do slightly different things, there is such a sort of interaction between the two sites that it's difficult to see them anything else as one establishment. There can be other issues with establishments. Vanessa mentioned, obviously, we're all remote working at the moment, and I don't think that should be looked at as we've all become an individual establishment. But certainly having, if as an organisation you are used to having remote workers, or you have workers who are peripatetic, so salespeople who go around or whatever else, then there can be more difficulty in sort of establishing what the establishment is. Do you assign them to a particular establishment, to a physical establishment, or do you treat the field workers as an establishment in their own right? It's difficult to be able to answer that in general terms. But again, I've run exercises where I've had the field operations seen as a separate establishment of themselves, and we've asked them to, we've calculated numbers in respect of that. I've also had situations where what we've done is assign them to the office to which they go most often, most frequently. So again, it's a question of looking at the specific facts of the situation. Vanessa, I think we had a couple of questions beforehand. Do you want to?
Yeah, we did. So we had a question which was, can notice of redundancy be given at the same time as consultation begins? Can they run concurrently, or does there need to be consultation then notice? Well, I think, we need to have some consultation before dismissal notice is given. You need to ensure that there is sufficient meaningful consultation, which I mentioned before. However, once you've consulted, and even if you're not at the 30 or 45 days, say you're even on, just say day 10, then you could potentially issue notice then. The length of the consultation is really going to depend, on the situation. For example, if you're applying selection criteria, then perhaps we need a longer consultation, because it always seems to be a sticky issue with the reps. But if there isn't selection criteria, then perhaps the consultation process will be shorter. I don't know, it's just an example. But yeah, we do need to make sure there's some consultation before we issue notice. But the key is that you don't necessarily have to wait until that end of the 30 or 45 days before you issue notice. And I think, and also even when you issue notice, you can still continue to consult in a way. Matthew, did you have anything else that you wanted to add to that?
No, I agree absolutely with that. It is a point which I've seen certainly with trade unions. However, they will challenge quite hard if you do give notice before the end of that consultation period. Just another couple of points on it. Certainly the dismissal can't take effect until after the 30 or 45-day period has expired. One of the things I think we've always got to be careful there is if you've got employees who say, well, can I go early? Because I got another job or whatever. My view is you really don't want anyone leaving until you've had the 30 or 45-day period. That really is the key, but certainly, yeah, you can give notice.
Okay. And then one other question that came in before the webinar was looking at a restructure. So if we don't have enough uptake for voluntary redundancies or reducing hours, could we invite everybody to apply for roles in the restructured organisation, and those who don't apply or are unsuccessful would then be potentially redundant? I think one point that wasn't actually in the question, but I would make is just a reminder that if we're looking at numbers for purposes of collective consultation, remember we'll have to include those that accept voluntary redundancy. And in terms of inviting everybody to apply for roles in a restructured organisation, well, that is kind of like a selection process in itself, and I think that principle it is fine. However, obviously you're going to have to be a little bit careful. For example, I suppose that would work if all roles are pretty similar within the organisation, and so the skill set requirements are similar. If not, then it might become a little bit complicated if you've just got a blanket across all departments and they all do different things. We're going to kind of put every role at risk, and then you reapply. That might actually end up being more complicated than actually looking at each different department, working out what you need and applying a selection criteria. Would be my view on that one.
Yeah, I've certainly seen it done in redundancy exercises where you say, right, okay, we're going to put everyone at risk and effectively have people apply for the new jobs, and it can work. It can work well if you've got a very radical restructure. It puts the onus onto, or the focus onto, effectively selecting appropriately for the new roles, which actually can't be is sometimes not a bad thing, because the requirements for an objective process tend to be slightly less than when you're actually selecting employees from a pool. However, I think practically it's a very, very disruptive way of doing it, because you effectively have everyone at risk for a while, and that can have a real effect on an organisation. So legally it can work quite well. Practically it's not without issues.
Yeah, I'd agree. I think that's all the questions.
Right. Okay. Well, on that point, then thank you very much, everyone, for listening. And sorry about some of the sound issues. We're going to do a few more of these, and we'll try and resolve the sound or the software or whatever it is, so that everyone can hear. There is a recording, however, of this, which we'll send out as well. Any further questions, anything we haven't dealt with, and you just want a quick word about it, then do give either Vanessa or me a shout, and we'll try and deal with it as best we can. We know these are difficult times for everyone, and we'll absolutely do what we can to help. And thank you for listening.
Yeah, thank you very much. Take care, everybody.